Good morning, Michael Popok.
Good
Once
morning,
again,
Karen.
once again, you're joining this special Trump on Trial edition of Legal AF Day 20. We're still banning Ben from as many videos as we can. I see him sneaking them on there. The guy can't stop working. He's just got married, and we're trying to force a little mini moon on him. But Popok, thanks so much for stepping in and joining me this morning to talk about what we're going to see today in court. I suspect it's going to be a very, very short day. We have the rest of the Bob Costello, the defense witness. It looks like the only defense witness that has been called. And we have the rest of his testimony and then some housekeeping things, unless, of course, there's a last minute decision, unless, of course, Trump at the last minute this evening decides he wants to testify, which would be quite the spectacle. But it's his right, and he has up until the time that the defense rests to change his mind and decide that he wants to testify. But we'll see. And of course, the gag order has absolutely no impact or effect on whether he can or not. I suspect that the judge will instruct the defendant that he has the absolute right to testify and make sure that he's the one choosing not to. And then if there's any other defense witnesses, or if the prosecution decides to call any rebuttal witnesses, and they're only at this stage, if they were going to call witnesses, they'd only be permitted to call witnesses that rebut any issue that came on the defense case. In other words, they can't put on any other, if they discover something that could have been put on, or that they should have put on, or they changed their mind from in their direct case, they can't do that. So the very narrow issue that they are putting on in a defense case is the only thing that they can rebut or put evidence on in a rebuttal case, if they choose to put on a rebuttal case. If not, the case is going to get adjourned for the rest of the week through the Memorial Day weekend, and we will expect summations next Tuesday. So today's a big day in the sense that I think all the evidence is going to be in, but the jury won't have heard closing arguments yet, and they will be instructed not to formulate any opinions, not to talk to anyone about the case. And so for a whole week, over Memorial Day weekend, they're going to be going to barbecues and they can't talk about it. Which is going to be so interesting and I'm sure difficult for them. But that's the rules and that's how it will go. So Popok,
Yeah.
tell me what you expect to happen today with Costello.
Well, let me go back to your comment about the jurors being instructed not to deliberate. Let's all remember, or for those that are just joining us, they're anonymous. So they've been told not to go out of their way. I mean, I know in the federal case, when they were anonymous for the E. Jean Carroll case, the judge says, you probably don't want to tell people that you're on this jury. So, I mean, I think this Judge Merchan has left it to the jurors to make their own decisions between them, their family, and their God about whether they're going to tell people. But let's be honest, they've already started to form opinions in their minds. They're not deliberating with others, but certainly they've started to form opinions from almost the opening bell in this case. I've been struck as we move into what looks to be the final day of evidence being presented to the jury, with both sides going to rest tomorrow, at how efficient this has gone. I mean, we're on day 20 witnesses, almost completely matches. They got basically a witness a day, up and off. I mean, it didn't exactly break out that way, but it's amazing. They got 20 witnesses into 20 days. And, we always talk about, as trial lawyers, the power of primacy and recency. The first thing you tell the jury and the last thing you tell the jury. And apparently Donald Trump's last thing he wanted to tell the jury, assuming he doesn't go on the stand, and I'd fall out of this chair and break my hip if that actually happened. He's not testifying, but the last thing that he wanted the people to hear, because apparently he made this decision, was Robert Costello, who was a very controversial lawyer in town, who's been sort of a political hack for a while for Donald Trump, going to Congress and MAGA Congress and defending Trump and attacking Judge Merchan and attacking Michael Cohen, who he used to represent. The rules of professional responsibility apparently have gone out the window, and so he has been a giant, what's the word? Burning clown car. I mean, it's just, he's gotten not just reprimanded by the judge, in yesterday's testimony, but admonished by the judge. And I think he sounded like he was this close to being found in contempt. And he hadn't even started. He was just frustrated because the Trump's lawyers couldn't ask a proper question and he couldn't give a proper answer and kept getting objected to. And so the jury has picked up on Bob Costello's shtick and doesn't seem like they like him very much. And as I predicted, jurors may have been separate individual creatures right before they were selected. But when they're bound together in a shotgun marriage of a jury, they grow together. And like in the organogram of the jury, they become very close. They're all doing their civic duty together, shoulder to shoulder. And they end up, if they have a good judge like Judge Merchan, who they respect, they end up respecting. He's almost like their boss. And they respect the boss. And they respect the process. And they don't like people who disrespect the boss and disrespect the process. And that's all we've seen out of Bob Costello. I can't for the life of me, and you and I did a hot take on it already, and we did it during yesterday's close. I can't for the life of me think of any value so far to Robert Costello going up on the stand, except his meltdown has drawn attention to the fact that Michael Cohen is a much more credible witness. So Michael Cohen is, of course, off. Costello will continue unless he can grow a brain and show up this morning, with a whole different demeanor and different set of facts. He's useless, but yet that's the last witness that has been put on, assuming that's true. Then there'll be some cleanup. We'll anticipate, right? As you talked about yesterday, there's the motion for directed verdict, which is always made. You have to make that, where the defense says no part of the indictment was proven. The entire case should be dismissed, taken away from the hands of the jury, and the judge, as a matter of law, should make the ruling. Newsflash: Judge Merchan is not granting that. He's already indicated in his skeptical commentary before issuing his ruling at probably today that he is not going to be entertaining that, and he's not taking this away from a jury that's been sitting there for 20 days. So you have that. Once that's dispatched and they're done, the question for you, I know they're going to, because of the holiday, it looks like that's it for the week. And then they're going to pick up on Tuesday with closing argument or summation and go right into jury instruction and deliberation. Is that your timetable?
Yeah, I think also today, though, I think they might have the charge conference, which is
okay.
Potentially.
Explain what that is.
A charge conference is so there's standard jury charge that every judge gives. Every judge has their own version of it, but it's standard things like a defendant doesn't have to testify, and openings and closings aren't evidence, only testimony is, and things that you can take into consideration, how to evaluate a witness's credibility, things that they say in every case, regardless of what the charge is. Then there will be part of the charge that is, and how to deliberate, and how to, all those things, what they're supposed to do. It's just their general, it's called a jury charge. Then there's a substantive jury charge on the specific law for a particular case. And that usually comes, they call them criminal jury instructions, the CJI. It's sort of these, anyone can look them up in New York, and you get what the recommended jury instruction is for judges, and they typically give it verbatim. Every once in a while, if there's something specific about a case, the parties will say, can we change it slightly to say something else, and the judge will rule on that and sometimes change it slightly, but there is a legal portion of it. And then there are the special requests from the lawyers. For example, the defense, I would suspect, is going to ask that the jury be given what's called the falsus in uno charge, which is a Latin phrase that basically means if a witness lies about something material, if you find that the witness willfully lie about something material, a material fact in their testimony, you are free to disregard the entirety of their testimony. There's another charge they might ask is that the defendant has a right not to testify, and that you must not hold that against him. There could be specific other charges. So I suspect they'll ask for those 2 charges in particular, and there could be others. There could be something about co-conspirators or corroboration or any other specific issue that one side or the other wants the jury to know or have specific language on. They will discuss things like that. That's a charge conference. The judge will then tell the parties what his charge will be, which is important. You kind of have to know before summation, because then you'll know what you are arguing, because in your summation, what you're doing is you're saying, these are the facts that support the law that you are going to be going back to the jury room and deciding on. And you want to know what the elements are that they're going to be charged on and what the judge is going to say. So you make sure that your facts that you argue about meet each and every element. Same thing with the defense. They're going to want to know what the elements are, because they're going to want to argue that this element or that element wasn't met. For example, here, that what they'll say in this case was Donald Trump. These people, maybe a crime was committed, but these people went rogue. Donald Trump knew nothing about it. This was Michael Cohen and Alan Weisselberg. They're the ones guilty of this, not Donald Trump. And the only person connecting Donald Trump is Michael Cohen, and you can't believe him because he's a liar, pants on fire. That's potentially going to be what the defense is. And, and they'll know that because they'll know what the charge is. So then, so that's what I suspect will happen today. Mm-hmm. And then, yes, they go into summations, defense goes first, prosecution goes second.
And the jury charge conference, of course, is done without the jury. And then all those decisions are made. Everybody's mindful of appeal. So you don't want to get the charge wrong, the instruction wrong. That's why, as Karen outlined, you try to stay as close to the model template as possible. And if you're going to change it, you better have a reported decision in your back pocket that supports it, because you don't want to have a reversible error moment where you've left out something, added an element that shouldn't have been there. I've had that happen, of course, in civil cases. So it is a high wire act on jury instructions and getting them right. If it's a simple case, it's simple model templates. Sometimes you're in a situation, not so much in criminal, but in civil, where you don't have a model jury instruction for the thing, and you have to cobble it together from either model jury instructions in other jurisdictions, or you have to make one based on the law. And that's always scary. And I've done that as well. In New York criminal proceedings, Karen, remind me, does the jury ultimately get a hard copy of the jury instructions?
No.
Okay.
No, they don't get that. And so I guess that's one other thing I can explain is they don't get that. And when they go back to the jury room, they don't automatically get the evidence or anything. They just go back there and start to deliberate. If they want to see any or all of the evidence, they have to buzz, right? You buzz once if you want something, and you buzz twice if you have a verdict. And so everyone bites their nails waiting for the double buzzer. And so, if you, I tried a case once with really, really, really gruesome, like the most gruesome photos you could ever imagine. So much so that I was worried that I didn't want the jury to become desensitized to the photographs, because they were like, if you see those photos, it transforms you forever, and it's so horrific that I won't even describe it. And so we try the whole case, and we tell the jury we're not putting it into evidence because it's too or we're putting it into evidence, sorry, but we're not showing it to you because it's too gruesome. But if, when you go back to the jury room and you're deliberating and you want to see them, it's exhibit number blah 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 blah. So they're in evidence if you want to see them, but we're not putting them into evidence. And so the jury goes back, and I mean, my supervisor at the time was like, "Are you kidding me? You didn't show them the photo? Like, the photo is the whole case." And it was like 10 minutes before they buzzed and asked to see the photo.
Yeah.
It was like the longest 10 minutes of my life, because I was like, oh my God, thank God they asked for it.
Oh, well, it was in evidence. You just didn't publish it.
Yes, correct.
Okay.
Yes,
all
yes,
right.
Yes.
But your boss was hanging on you like, what do you mean you didn't publish it?
Yeah. My boss was like, are you joking? How like that? What if they don't ask for it?
Because
like,
they hung on your every word, and they wrote exhibit number.
Yeah, well, whatever. The point is it was a little unorthodox, and but they buzzed. They got the point. My point in all this is they have to ask for the evidence, and if they ask questions about the charge, if they to answer your question, if they want charge read back, the judge doesn't typically read it. The judge finds it in the record, and the court reporter reads the portion of the charge that the judge read, just like the court reporter would read any portion of witness testimony that they want read back.
Yeah, very interesting. On the and just as a last note on that, from a trial lawyer perspective, yes, when they ask questions and have to have them answered, or they ask for certain pieces of evidence, we do speculate about whether that's good or bad for our case.
It's horrendous. It's the worst. It's
why do they want that?
Yes, it's the worst. They send a note, and you literally, it's like, and everyone talk, they say, what are the tea leaves? And the one thing I've learned is you're almost always wrong.
I agree with that. I totally agree with that.
Right? It could be one juror who has one question, and the rest of them want to just remind that one juror that juror is wrong. And meanwhile, we're thinking, oh my God, they care so much about this one little thing. Why did they care about it?
Well, as an example here, like if suddenly they said, we want to hear from the accounts payable supervisor, and her state, we're like, holy shit, they went to that level. But you're right. It doesn't have to be that. It's just somebody had an itch to scratch, and they needed to satisfy them. As you said, the rest of the jury was arrayed against them, and they needed to say, no, you're wrong. And then that's what's going on.
I know. Sometimes they'll say, we want the cross-examination of this witness. And the prosecution is like, what? No, you have to read the direct and the cross. Right. And the defense is like, they only asked for the cross. And you're just, and you literally have those battles. And then the court,
let me ask you a question, because you and I like betting. I'm paying off my bet tonight, by the way. Here's the question. What is your prediction as to whether Todd Blanche and Susan Necklace, on behalf of Donald Trump, asks for the lesser included offense misdemeanor charge as an alternative for the jury?
So it's not fair, because I know the answer to this question.
How do you know that already?
Because there's only one possible answer, and that is no, they will not. Okay. And the reason is because the statute of limitations has run on the misdemeanors. And so this is either a felony or it's nothing.
That's very interesting. So
the defense could waive the statute, but why would they?
So the statute of limitations on the business record fraud,
on the misdemeanor
part, has run, but they could still waive. They could waive.
Yes, you can waive, but why would they? They're not going to waive. That would be the dumbest move ever.
It would, because you don't want to give the jury an alternative exit ramp that leads to a crime.
No, not if you have a free. If the statute hadn't run and I was the defense attorney, I'd probably ask for the lesser included, because I'd rather have a misdemeanor than a felony. But because the lesser, and the judge can do it sua sponte, by the way, it's either party asks for it or the judge can do it. It's a pretty lenient standard. If any reasonable view of the evidence supports the lesser included, they submit the lesser included.
Which means that the judge or somebody would have to find that there is a crime here that only is a standalone business record crime, not in furtherance of a second one, because it has to be,
or that a reasonable view of the evidence could support that. Yeah.
Right.
So it's a pretty easy standard. So if either party asked for it, the judge would likely give it. If they didn't ask for it, he might not actually give it.
Do they ask for it?
No, they won't ask for it, because because the statute has run. That would be stupid. So no,
I'm on the edge of my seat when we do legal AF or versions of these things. I need to know these things too.
Yeah. All right. So it's either a felony or it's nothing, or it's hung. Those are the options.
Well, we got a lot to talk about in midweek. We got a lot that was Wednesday.
And I can't wait for dinner tonight.
And dinner tonight with we're bringing a special guest with us, and then Saturday with Ben. Well, thanks for having me on. It was a great idea to give Ben a break.
Well, thanks for coming on, Pope. I'll see you soon.
You too.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the Midas Touch newsletter at MidasTouch.com/newsletter.